I said like going on dangerous adventures,
Eh,
like yes, like skydiving or jumping from a high place and all those things that people used to do. I said that that can serve as consent to
okay.
danger.
If
Yes,
you
ma.
go and engage in an activity that is traditionally dangerous, and in this video we talked about sporting activities that are, any activity that you engage in, you take the natural consequence of that activity. Okay, so let's leave the volunteer for now and let's go to the. I know that some people's answers were raised. If I have not called you, please, we need to move to the next topic so you can speak on the next topic. So please, as an assignment, list these examples that you are giving me. When we meet next week for the tutorials, we'll be taking some of these as and analyzing them, whether they constitute real examples of voluntary non-fit injury. Okay, so that we can take other issues. So as it is now, what we have taken out of this discussion is that the question of voluntary non-fit injury is a question of a defense in negligence, and if it is canvassed successfully, it has its consequences. If it's not successfully canvassed, it may be a case of contributory negligence, and both of them have their different consequences. A student is expected to be able to distinguish the two, for instance, and tell us the difference between the two, and tell us the elements, and in particular, to be able to give examples of what incidents you think would constitute a case of voluntary non-fit injury, because you would have seen that the fact that you are going through an activity does not mean you are consented to the risk of that injury, of an injury. Otherwise, every time you enter a vehicle, there's always the risk that the vehicle will have an accident. Every time you board a plane, there's always that chance that it could crash. It does not necessarily mean that you are consented to the risk of negligence on the part of the person. So there are things that are a natural consequence and reasonably foreseeable part of a process, and there are things that they are not natural, and when you see them and you decide to consent to engage in them, or then it can be said that you have been violence, so to say. So let's take last week, I think we have looked at contributory negligence as a defense. Please go and read that up as well. Then let's go to I think the only thing that we should take now, so that I can actually touch on all the lecture topics, is res ipsa locutor. Res ipsa locutor. So I need someone to tell us what they have learned from the video on res ipsa locutor. Hello. So do I have any volunteer? Daniel, okay.
Good
Joy.
morning, ma.
Good morning.
Good morning, ma.
Good morning.
Okay, so
Go ahead.
yes, ma. So the doctrine of res ipsa locator, it literally means the fact speak for itself. So res ipsa locator is an evidential rule, not a substantial rule, and it deals with proof of negligence. So the general rule is that the burden of proof of negligence rests on the plaintiff. However, the facts of the case may suggest that a negligence has taken place. And so where the defendant lacks an explanation of how that negligence occurred, but the facts are so obvious, he can plead res ipsa locator. Okay, so in the case of Scott versus London and St. Catherine's Dock Co., the court held that facts that showed normally that what happened wouldn't have happened if there was a want of care, then res ipsa locator could be pleaded there. So this is where the cause of the damage is unknown, as I earlier said. And so elements of res ipsa locator is that, number one, the thing that caused the damage was under the management or control of the defendant or his servants. Number two was that there's a lack of explanation by the plaintiff. So where the plaintiff has evidence, then that would absolve the need to plead res ipsa locator, as held in the case of Backaway versus South Wales Transport Co. And then the third element is that the accident does not normally happen without negligence on the defendant's part. So human experiences must depict that the occurrence was unusual unless there was negligence. So for example, a bag of cement that fell off the 11th floor of a building and hit a pedestrian on the road. Normally, a reasonable man would think, like his mind would go that, oh, there was a negligence there. And so you gave examples of using case laws, examples of let's say a fact that one can plead res ipsa locator, like the case of Mahon versus Osborne, where there was cotton wool in the patient's abdomen after a surgery. Then, in the case of Cassidy versus Ministry of Health, where the plaintiff was having a stiff finger, but after the surgery, he came out with four stiff fingers. In the case of Edison versus Allow, where a driver hits a person from behind. Also, other instances, like one I can think of is when I unknowingly bought petrol that was mixed with water from a filling station. It's now ruined my car. So there I can plead res ipsa locator if I bring an action against that filling station. Then someone goes for, you also gave the example of someone that went for so, surgery with one bad eye, but when he came out, both his eyes were bad. And so as earlier said, res ipsa locator is an evidential rule, and so it's prima facie evidence of negligence against the defendant. And when it is pleaded, the body now shifts to the defendant, and so now it's up to him to show that he has used reasonable care. That despite the use of reasonable care, what happened couldn't have been prevented. Let's say an act of God or inevitable accident, or maybe even an act of the plaintiff. So that's it, ma. Thank you.
Wow, that's a very good summary of the process. Yes, because the main principle constants that it applies. Can someone assist us to take it further? Let me see. Is the same people that are still having their hands up? Akimbo Ade. Akimbo
Good morning,
Ade.
ma.
Good
Good
morning.
morning. Okay, so I think the most important thing in res ipsa locutor is that okay, so res ipsa locutor translates to the fact speaks for itself. So inferring liability, the fact that can be presumed from the circumstances of the case. So when it applies, the burden of proof that is usually on the plaintiff, now shifts to the defendant to prove that he or she was not negligent. And like Joy has said, it is an evidential rule, is not based on substantive law. So you gave the example of Scott versus London and St. Catherine .co, where the claimant was a dock worker who got injured when a bag of sugar fell on him. And we talked about you talked about Brian versus Bordeaux, the case of Brian versus body, which was a similar case where somebody was injured. So the element, and I think one of the most important elements in this doctrine is that there must be a lack of explanation by of the cause of damage by the plaintiff, due to the fact that in the case of Brian versus Bordeaux, he was unconscious when the barrel fell on his head. He was not unconscious, so it was they required the witnesses to state what had happened because he himself did not know what happened. So the court established that one of the most important elements to establish to use that doctrine, to apply that doctrine, is when the plaintiff cannot explain what happened. So when the cause of damage is not known to the plaintiff, we use that rule. So the other element is when the accident is caused by items under the defendant control, just like she said. So I don't want to repeat everything that she has said. So in the case of Backaway versus South Wales Transport, the doctrine did not apply because the plaintiff was able to state the cause of the damage was known. So the plaintiff took a bus and the tire burst. Despite he burst because of the fact that the driver did not check the tire before moving, which was one of the rules of the company that the drivers were required to check the tires before moving. So despite the fact that yes, they were negligent on their part, but the fact that the plaintiff knew and the cause of the damage was known, the doctrine did not apply. So he said that it must be clear and demonstrated knowledge, the fact that the kind of event does not normally happen. So the so a reasonable man, he must be able to tell that this action will not have occurred unless there was some sort of negligence negligence rather. And he talked about the effect of reps ipsa locutor, and he said it creates prima facie evidence, so as face value against the defendants, meaning that the occurrence of the accident is enough to suggest negligence, like the case of Bayern versus Bordeaux, when the barrel fell on from the top of a building on him. So if they had actually like hoisted the barrel very well and kept it well, obviously that would not have happened. So and it shifts burden of proof as we've already established. And then the legal implications that the plaintiff would succeed if the defendant fails to disprove negligence. So now when the burden of proof falls on the defendant, it is now his job to to prove that he was not negligent in his action that caused the injury to the plaintiff. So they can succeed if they show that they were not negligent or they met the required standard of care, and they may escape liability in cases of inevitable accidents, the acts of God, and the acts of plaintiff that's contributing negligence, because it was held in Cotton versus Woods when a driver driving a car, he hit someone and then she got injured. But then the court held that this doctrine cannot necessarily apply because both the driver, the defendant, and the plaintiff, they were both negligent because she was not supposed to be crossing that part of the road was not meant to be crossed by pedestrians, and she crossed it at night. So despite the fact that the driver was not paying attention while he was driving, um she also was not meant to have been crossing, so there was it was contributory negligence, so it could not apply. And then so acts of a third party or a stranger too, so or there was a new intervening, like that is no access intervening. So these are the cases in which the if the defendant can succeed in proving that he was not negligent, if he will not be liable, but if he fails to disprove negligence, he will be held liable. I think that is all. Yes, ma'am.
Thank you very much. I think that the way you guys have been discussing, those who have been contributing to the class, if you can get everybody to that standard, I'm very confident that we will have a very good result with these topics that we have treated, at least in terms of being able to evaluate issues. The speakers who have spoken now have told us, if you are spoken, you can put down your hands so that we know those fresh, if there are fresh hands. Okay. And they've told us clearly now what is res locutor. It's a way of proving evidence. The thought is a bit always dicey. Some people will feel like it's like a defense to an extent, because in practice, all these things you are talking about, you must court to court and prove somebody owes you a duty, somebody has breached their duty, and they cause damage, and that damage is as a result of their breach of duty. So that link between breach of duty and the injury that occurred, we say causation. You must find the causation. The chain must not be broken. The causation link. That means in the civil cases, by now they've told you, I'm sure, that the burden of proof in civil cases generally lies on the plaintiff, while it lies on the prosecution in criminal cases, except some exceptions like insanity and what have you. Be that as it may, therefore, in all the cases we've been talking, topics we've been talking about, and thought the burden of proof is usually on the plaintiff. So when you have a case of negligence, the plaintiff cannot just come to court and say, this man was driving and he hit me and I am injured. Or, litigation is not like that. The court must see evidence step by step, and it is the duty of the plaintiff. So the examples that you've seen in those cases, traditionally it was the duty of that when these stick fingers that I am now suffering from is as a result of negligence. This cutting wound is as a result of negligence. This injury from the vehicle, this burning of the house, this, all those things is a result of negligence, and that causation must be established. How did it happen? We don't just say it's negligence. Causation, you must tell us how it was caused, So, but the law recognizes that there are some things that you will not be able to prove because of the way, the circumstances of occurrence, the information about how they happened. When the bag of flour fell from the top of the building, for someone that is downstairs, that it fell upon, how would the person know what caused it? How would he know? If you say the burden of proof is on you, you must prove your own reason. You must prove on the balance of probability. In civil cases, you prove on the balance of probability. So how does the person establish it when he was not in the building upstairs to know what happened? So some people can say, I'm not the one. I don't know how it happened. The defendant will say, so the court in such cases where those elements that they've mentioned to you must be established. Oh, this thing is under your control. So the bag of flour, who is in charge of it? Okay. And ordinarily, they are not birds. They don't have wings to fly. So it could not have flown. If it was a bird that flew, we can say, okay, this is natural thing that birds do. But flowers they don't fly. People don't grow scissors in their womb or cutting wood. A finger does not become stiff just like that. Something must have gone wrong somewhere. This plaintiff who is suing the hospital, who is suing the owner of the flour, who is suing the driver, does not have the information about what happened. What happened to the vehicle that skidded? What happened to the flour that came out of the hammer that fell? What happened? So the law will say, okay, once there is no evidence, and that point that our last speaker, is it Akínbọ́ládé made, that look, there must be no evidence. If you already have the evidence, you knew that flower fell because A was trying to stack the flowers and he was throwing them on top of each other. And when he threw one, it threw it too high and it came out of the window. If you have evidence about how the incident happened, you cannot use res judicata. It's an evidential rule. It is a rule that discharges the need to prove causation. So if once there's evidence of causation of how the thing was caused, you will not need to rely on the maxim. The elements that they have described to you too must be established. If the thing is not under my exclusive control, for instance, if it's under 2 or 3 people's control, you cannot presume that I am the one that caused it. So that's fundamental point about being sure that there's no evidence of how the thing happened. You must show that it is the case. Then the consequences, once you say yes and so it doesn't mean that you have won the case, like you say. So the effect of the doctrine is to take place. Adekile, you want to say something?
Yes, ma. Good morning, ma. I have a question. Ma, can I go ahead?
I can hear you. Adekile.
Okay, ma. So in the first element that says the accident causing
Can you guys
item
hear
has
me?
yes, ma.
Can you hear me?
Yes, ma. Yes, ma. We can.
Can you hear me?
Yes, ma. We
Yes,
can hear
Okay,
you.
yes,
no.
ma'am.
Class, can you hear me?
Yes,
Yes, ma.
ma'am.
Yes,
We can hear
ma.
you.
Hello?
Yes, ma'am. Can hear you.
We
We can
can
hear you
hear you.
clearly, ma.
Can you hear me? Class?
Ma, we are
Yes,
hearing you.
ma.
We are
We can
hearing you.
hear you
Yes,
loud
ma'am.
and
We can
clear.
hear
Yes,
you,
somebody
ma'am.
said she has a question and I said she should go ahead. And I didn't hear anything again.
No, yes, ma. I was speaking. It was probably the network. Okay, so in the first element that said the accident causing item is under the defendant's control, you mentioned something about joint when there's joint control. He said that the doctrine is inapplicable. So what would be applicable in that sense when the item is has
Please
joint
hold
control?
on. I'm trying to do something to my. Okay. Okay, repeat your question now. Repeat your question.
The accident causing item has to be like under the defendant's control. So in the video, you mentioned something about where there is joint control of such item. You said the doctrine of res ipsa loquitur would be inapplicable. So what would be applicable in that sense?
Then you have to prove who caused the accident, who has control. If you bring a plaintiff to court, only one of the plaintiff, okay, and you are claiming res ipsa loquitur, the person will say it was the other person that caused it, the other institution or whatever. So you cannot presume that this person has been negligent where two or more people are in control, of the incident causing item. So you cannot say res ipsa loquitur in that context. But if you brought two of them to the court as joint tortfeasors, maybe an incident that is multiple causes or successive causes and whatever, you can raise res ipsa loquitur against the two of them. But when you have one person and the person says, I am not the one in control. Look at the bag of flour, assuming that it was a cement company area, and this bag of flour fell. And many people are in control of bags of flour. There's no way to distinguish who owns the particular one that fell on you. You are now bring one person to court and say res ipsa loquitur. The person will say, you to prove that it's my own bag of flour that fell on you. So that's why there must be clear case that no other person, no third party interference would have taken place. Nobody else would have
We can't hear
had
you. Your
control.
network is not clear.
Pardon? You cannot hear me.
We can't hear you.
We
Your
can hear
network is
you.
not clear.
We can hear you, ma'am.
We can hear you.
Somebody is complaining that they cannot hear me, and I'm wondering why. Okay, so that's why that doctrine applies exclusively to these situations. If somebody else has control, two or more people, and you bring one person to court, you cannot apply the doctrine. You cannot say it is clear now. In Yoruba, we say "Arun ojú ni." It's a disease of the eyes now that the eyes you can see clearly that this person is is the one that is at fault. It's like, for example, if there are two drivers who have run into a particular plaintiff at the same time, and you now bring one driver to court and say res ipsa loquitur. Two people had control of the things that caused the injury. There are two vehicles. So how do you know that it's driver A that was negligent, or driver B? So that's why the law has created the framework within which it can apply. If it doesn't apply, the burden of proof remains on you as a plaintiff to prove causation. And you cannot prove causation, then you may lose the case. And when we take some tutorial questions, you see some examples in this context. Okay? Onodike,
Thank you, ma'am.
Abib.
Good morning.
Good.
Actually, My question has been answered. I forgot to put down my hand. So it's based on, I wanted to confirm. Can you hear me, ma?
Yes, I can hear you.
I'm sorry about the background noise. I'm in a barber shop to chat my, there's no light around. So what I wanted to confirm was that the connection or the nexus between multiple causes and res salupito. But it seems
Yes.
by your response to the last person's question, by your answer to the person's question, you are able to answer that. Thank you, ma'am.
Okay. Okay. Who else? So you can put down your hands, Abib. And any other person that's Oniye. I've
Hello, ma,
not
can you
called
hear
that.
me, ma?
Yes, I can hear you.
How do we differentiate res ipsa loquitur from the two hits on task cases?
Can somebody answer the question? How do we differentiate res loquitur from the two hit hunter case? Can you explain to them? Maybe some of them have not watched you. What is two hit hunter case?
Two hit on that case, you gave the cases whereby there were three friends that went to hunt, and one of their friends were like, "Don't shoot here," something like that. It was in front, and two of them simultaneously shot directly at him. He didn't know who exactly shot because it was not facing their direction, and he sued both of them to court. Then Rep. Locutor, you said the claimant does not know, the person does not know exactly what caused the matter or what caused the damage itself. So I don't really.
Can somebody answer that question? Can somebody answer that question?
Can I try, ma'am?
Yes.
Okay. So my own perspective to that question is that if we should apply um the two it on that case, or yeah, in a reprisal episode circumstance, the defendants are likely to escape liability because we are not so sure that okay, the damage or the injury is caused by a particular source. It's flowing from a particular source because the what's it called? There is like a form of discrepancy between two persons that okay, I'm not the one, you are the one, you are not the one. So we are not so sure. But let's say, for instance, we are sure of the person who exactly is in control of what caused the injury, that we know that, but we just don't know the cause, then Repsisal Ekuto can apply. But where we are not so sure of the source of the injury, and we cannot give explanation as to how that thing happened, then I think that tilts towards the two it hunter case. That's my perspective. Thank you.
Hello,
Okay.
ma'am. Sorry, ma'am.
Yes.
You gave an example where a claimant was on the road and two buses hit him at the same time. And he said that was example for res interlocutor and not two in total case.
Now, let me say something. When you talk generally, when we answer specific questions that you throw at us, you must be clear what your question was before we spoke. The link between those two hit hunter cases and res locutor is not just about control. You know, we said that fundamentally, the first thing about res locutor is that it what? Fundamentally, to apply that doctrine, something must
But
You said it's an
there must be a
evidential
lack of
rule.
explanation by cause of
lack of
damage.
explanation. Lack
There
of
must not be explanation.
explanation. There is no explanation as to how it happened. Okay? The two hit hunter cases, the two accident cases, if there is explanation as to how these things happened, and from the two hunter cases, you would see there is evidence that the two of them shot at the plaintiff, at the plaintiff. So you know what caused the injury. I mean, you know how the causation aspect. You're not talking about, we don't know whose bullet it is now. What caused the injury? There's explanation that they took their guns and they shot at the plaintiff. And one bullet hit the plaintiff, or two bullets hit the plaintiff at different points and he died. We don't know the impact of which one that killed him, but you understand? There's explanation of how the incident happened. Causation is established. But to the extent of proving how the incident happened, how did it happen? And we know that these are the likely plaintiffs, the two of them, and likely defendant. It's between the two of them. You will not apply res ipsa locutor. But if you didn't know how it happened, and you must continue to remind yourself of that. Once the defendant gives evidence and says, and the plaintiff gives evidence and says, on this day, as I was going, suddenly I saw this man, he was using the phone, and then he gave an evidence as to what happened. There's evidence before the court that these are the things that happened and the accident resulted. You don't use res ipsa locutor. You don't have to be finding out whether the thing was under the control, because all those elements must be complied with collectively. You don't have to be going then further to be saying, was the thing under your control? Because the evidence you are giving would have shown that the thing was under the person's control. It's about facts, okay? Giving evidence of facts that have transpired. If the doctor, if there's cotton wool in somebody's stomach and somebody was able to provide evidence as to how it happened. I was watching a film yesterday on medical practice, and this woman has been complaining of pain in the chest for 5 years. And they used to think it's in her imagination because she was elderly. It's her imagination, it was this or that. Then they brought her to the hospital for something, and she was still complaining of that. By then they opened her up, they found a towel in her chest. And they quickly went to go and check their records, who was the one that operated on her 5 years ago. Incidentally, it's the same set of it's the same surgeon that operated her 5 years ago that was operating her now. So now, if somebody was able to come and tell us, this is what happened. This is the age of technology, for instance. Assuming there was a video recording of that process, and we can see what happened, how the towel was forgotten. It can be scientific. Whether it is two, it is one person is before the court, whether there are two defendants, joint officers, like the two other case, it does not matter. Res ipsa locutor will not apply. Can you hear me?
Yes, ma'am.
Yes,
Thank
ma'am.
you, ma'am.
Yes. Yeah. So if they give you a set of facts and the facts describe, this person did this, he did that, and that's caused you don't even, but res ipsa locutor will not apply. But if they just tell you that, and your questions, and in practice, it will be obvious to you the ones you can apply res ipsa locutor to, because you will be sure that you will not be able to prove it. Look at Donobu and Stevenson. Do you remember that case? Do you remember Donobu and Stevenson?
Yes, ma'am.
What happened in Donobu and Stevenson?
In Dono and Stevenson, Miss Dono and her friend went to a cafe to get drinks. So they ordered a ginger ale drink, and it came in an opaque bottle. So she had already drank almost half of it before her friend poured it into a tumbler, and it revealed that there was a decomposed snail inside. So she fell sick after, and she had her intestine got enlarged. So when she brought a suit against the manufacturers, the court held that they owe the duty of care. The manufacturers owe the duty of care to anybody that is going to be purchasing their drinks. So that was the decision. Yes, ma'am.
Okay. Now, if you are in court, what do you think the woman must prove? What do you think the woman must prove?
That the manufacturer had the duty of care to her.
Yeah. Is that all? Is that all that you must prove in court? Habib, is it Habib that is talking?
I think you also have to prove that it was the manufacturers that put the snail inside there, which she wouldn't have been able to prove.
Exactly. You prove duty of care, you prove breach, you prove damage. That has taken place from the facts. because there is evidence that she had health issues and all those ones. And now in practice, actually, the court will take judicial notice of it, that a manufacturer has a duty of care to the. But in the particular case you are taken to court, it will be expected of her to show how the snail got into the bottle. The burden of proof on the plaintiff in that kind of is to tell the court how it's not sufficient to say I bought a bottle of drink and there's a snail and I drank it. Do you understand? Do you understand? It is the burden. It is the burden that the plaintiff must come and prove in court that okay, so this you said there is a snail. Tell us how the snail happened. Okay, to be in the bottle. Now you bought it and you opened it. You will not know how the snail got there. You will not be able to prove. You were not in the factory. But we know that ordinarily snails don't grow in bottle. So those aspects of res allocutor would have been met. So it is the only way is to shift the burden of proof, because what res allocutor do is to shift the burden of proof on the defendant to come and tell us that snail got there not out of negligence. It will shift the burden of proof, because she cannot tell you, Mrs. Donoghue will not have been able to prove that Stevenson, this is what they did in the factory that they did not do well. Oh, they should have closed the drink container when they left it overnight, and in the environment they are living, they are manufacturing is a forest area, is a muddy area. There are snails about, and one snail must have jumped into it overnight, and there's no evidence of that. And it is expected that you can't just say because after all, maybe somebody had opened that drink, put the snail inside, and not near a bottle, put the crown back. There must be no evidence that a third-party interference has taken place. If there's evidence of third-party interference, somebody else could have done something in the process of causation. You'll not be able to use res allocutor, because the law must be sure that the person that brought to court is the one that caused the injury. So that's in practice, therefore, we give you the average. The injury will not usually be a duty of care in most cases. So a lot of cases is we evidence. Oh, have you breached it? What is the standard of care? It's objective test. So the causation, have you been able to fulfill the causation requirements, foreseeability, and this and that? You apply all those rules. But now you cannot establish causation because you have no information. So because there is no information of causation, we shift the burden to the defendant. Defendant will not have to tell us how it is possible for snail to be in a bottle. Maybe you come and say, establish that actually this bottle of drink you bought is a fake one. It's not from our factory. It is made at Mushin or Oluwole, and it gives us indicators of what it is, how it is affecting. Maybe you come and tell us how, anything, just to shift the burden of proof. So the issue of even if you brought two people to court as joint plaintiffs, joint defendants, joint hospitals, you can still use res allocutor to show that you did not know how it happened, but you know that these two people were in control. Okay, they're in control of a gun. So it depends on the fact. It's a question of facts and law. Fact and law. And the fact will determine. If I told you there are two people in control of a gun, and the two of them shot in the direction of the plaintiff, and the plaintiff is hit, we know what happened. They put up their gun, they shot in his direction, or they shot at him. There is evidence of what happened that caused the injury to him. What we didn't know is if when bullet has hit the plaintiff, which bullet hit him? Which bullet hit him is what you don't know. But you know how the bullet got to his body, that these two people shot at him. Or if there are two bullets that hit him. I don't know whether I'm communicating with you. Class.
Yes, ma'am. Yes, ma'am.
Okay. So you think through those informations I've given you, and would take some scenarios during our tutorials. Okay. So just put those principles at the back of your mind, and be clear on your mind that rest displaces the need to bring evidence because lack of available evidence. What it does is shifting. It doesn't mean 20. What happened? Oh, I was glad that fell from the roof. It fell because there was an earthquake, and that was how the bag flew from the building. Act of God. You know, he can bring evidence that shows that he was not negligent. If he brings evidence that shows he was not negligent, then the plaintiff will not be able to win that case on the face of it, relying on that principle. So that's the most I want to say regarding this aspect as of today. You must take note of the meaning, the elements when it would apply, the treat it one way or the other of the doctrine. You must understand the effects of the doctrine as well. Okay? The same thing with volunteer non-fit injury, the same thing with contributory negligence, and every other topic that you have treated. What I expect you to know, if it's trespass to persons, trespass to goods, trespass to land, what else have we treated? What topic have we treated? I think those are the topics you've treated in this semester. Trespasses and negligence. Am I right? And the introduction. It appears you're not hearing me.
Yes, ma,
We
you're
can
right,
hear
ma.
you.
Yes, ma'am.
Okay. In every such topic, look at the meaning of the topic, the definition. When you look at the definition, embedded within the definition are the elements. Then look at where there is controversy. Can you trespass negligently or intentionally? Is it those sub that the lecturer has given you? Can it be false imprisonment when somebody is not aware of the imprisonment? Is it false imprisonment to poison somebody? Is it direct or consequential? All those little details. In fact, you can prepare yourself MCQ and to make sure that you get to the details. So reach with that kind of mindset, and then put yourself in your hand, like you're in a hand chair and you're thinking about life and the things. What Tort is about social and economic interaction. Tort law. When you look at all the principles, it's about social and economic interactions. What happens when you're on social media? What happens when you're on physical land? What happens when you're in business? That's all the things we're talking about in tort. So you sit back, and these are things that you can relate with every day. I'm sure now that you said studying tort, some of the things we do in life, it's about many things. Someone said it's in the barber's shop. The barber give you consent to come to the shop and listen to lectures. If you didn't, what is that? Trespass to land. If you are there and they are listening to the lecture, he cuts your hair, he barbs your hair, and says, this person is sitting on my chair. I begin to barb your hair. Do you know you came for lectures? What is the meaning of that? Is that battery? Is there any defense you could raise? There are things that happen into you that you relate with everyday realities. Okay, this is encompassing. You see so many things that happen in life, and you understand why if you see somebody constructing a building, you see that usually they will have scaffolding, they will have things that they use to cover up the building. One day you just see they open it up and you are seeing a building. It's because of the issue of negligence. Because in past you see people building a house, armor will fall on pedestrian. It's a clear case of negligence. Rest is allocutor. So you cover up the environment, then you have the health safety and environment. You have medical negligence. It's subject on its own because it's very wide. You cannot just take it. You have negligence of professionals, negligence of lawyers, aspects, and you see it every day. You see things happening now in social media. Somebody will give their system to somebody to repair. What happens? They will pick up all the things, that videos and whatever, and they will upload it. And these are things that we can relate with. Somebody does not like your face and he puts a drug in your drink. Is it trespass to persons? Is it somebody takes away your clothes And then where is it without your consent in the hostel? Where's your shoes? And say, yeah, this is my roommate without your consent. Somebody steps on you in the bus at the bus stop. These are things to relate with. Like, so it's about social relationship and it's about economic or business relationship. We look at those economic aspects in the second semester. We have been dealing with, generally social aspects, although negligence covers both economic and that's why we looked at medical negligence, negligent misstatement. It's about your words, what you say, the weight the law attached to your statements. It's about the weight the law attached to your actions, even to your omissions when you refuse to do something. Affirmative action, is there a duty to do something? It's about it. It's about weighing your actions carefully before you do them so that you don't run foul of the law, irrespective of whether you have a relationship with that person or not. Once the law can say this person is your neighbor, this person is in a particular relationship with you, then you'll be able to say, I have to be careful the way I behave. It's about how neighbors behave with each other. What can you do legitimately on your property, and that, and where is the boundary in terms of behavior? Even though you are the owner of your property, but can you just do anything as you like, irrespective of how your neighbors feel? So these are some of the things. There are things that are relatable. That when you get home, you can see your parents doing something, or you say, what do we do? And I mean, you can't do that too. You can do that. So these are, if you don't begin to sit back and relate these principles to things happening in society, and that's why I said when it came to volunteer that you should bring out examples of what you think. Think about it yourself. What do you think about some of the practices that you see in society, whether as volunteer not in Nigeria, whether as contributory negligence, whether as rest is allocutor. If you are doing that, you give your critical thinking, it will be easy for you. Even if they bring the question with facts that you didn't think about, it will be easy for you. And it will surprise you, because lecturers, I'm not going to heaven to bring out questions to get it, I'm going to sit back to the way I'm telling you and look at what is happening around you and use it to set questions. I'm going to look at you are not on ground now in campus, you are doing virtual lectures. Is there something I can create out of that? Is there anything that can resonate with thoughts, with family law, with contracts? Is there anything that can resonate with constitutional law, with land law, and what have you? And if somebody picks my phone and decides to use it to take lectures, or my laptop or my system, or plugs their whatever charger onto in my office, there are things that you can just sit back and it should surprise you that you can actually preempt your questions. And that goes on with every subject that you are taking. What is happening in governance? What's in society? If we are taking which other subjects are you taking? Criminal law. And some things are happening in Nigeria, globally. You must be students as lawyers, you must be people of the world. People of the world, not of the world, if I use my own faith to describe. People that you are conversant with what is going on across the world, in your country. That is where the lecturers will get inspiration to set your questions. That is where they will get the inspiration. Something is happening in the National Assembly, something is happening in a state House of Assembly, they've impeached this person, something is happening in the criminal justice system, those are the things. And sometimes your lecturers will come and raise those issues with you in class and say, let's have this thing, did you read about this thing? Now you are being taught, they're talking about libel became the issue towards the end of last year. Second semester, we'll be looking at libel and the issue of whether the laws regarding criminal libel. So your criminal law lecturers will be interested in that. Your tort lecturers will be interested in that, because that is on the front burner in society. So don't just read and just close your mind to textbook reading. Read like someone that wants to understand the law, not just that I want to read and drop everything for them and pass. Because if you do that, you may be able to relate to me the principles from the video, but you may not be able to apply it when I give you a question. You're not be able to apply it because you didn't think, you didn't put on your thinking cap and have some critical evaluation of the information that you have obtained. And I think that's one of the things that students do not get. So when they get to the exam or they see a story and they are disoriented, they are confused. See, I don't even know what this thing is about. I don't even know what they are talking about. But by the time you give the example and your eye clear, you seem like don't just remove the veil. You say, this is what they are asking. No, see, the name is this case that we should have used. Is that case? Anyway, we go ahead and discuss these things during tutorials as well. Okay. Is there any topic that is in the video that we have not looked at? Daniela and is it Mayowa? Do we have the list that I sent? What is there any video that we have not touched upon? Or any lecture video?
I don't think so.
Okay. So it's a busy day for me. I have like 4 lectures, and so I need a break in between. So what I will do now is that I've seen your class reps and they've given me the past question that we should be treating during our tutorials. So I appeal to you. It will be beneficial for you to have the framework of answers. Everybody in class, I could call anybody, and prepare your own answer to those questions. Don't come online and just sit down and just read the question for the first time. Look at the question as sit down and attempt an answer. Structure it and let's have your answer discussed. When you don't say what is on your mind, you cannot know how to guide you. So during the tutorials, the questions are with you guys already. Let everyone sit down. You are not going to write joint exams, and you're not going to solve. The people that have been talking in class are not the ones that will write the exam for everybody. So you may say, "Oh, I've not spoken and I've escaped." Any escape you think you have is, it's at your disadvantage. So the questions, try to answer them yourself before coming to class, so that number one, our discussions will be richer and it will be faster. You can take as many questions as possible. Okay. So, is there any question?
Yes, ma. Sorry to interrupt you, ma. Please, ma, your slides from the video on contributory negligence, some of these slides were not like clear enough. Like it was too enlarged for the screen, so I could not read what was on the slide, and you were not reading out of the slide exactly. So, ma, if you can like kindly provide us with the
Yeah, okay, I
slides.
cannot hear you.
Hello, ma. I said that your video on contributory negligence, some of the slides, like we could not see what was written on the slides clearly because like it was too enlarged for your screen. So we could not read the slides clearly, and you were not reading exactly what was on the slides. So if you can like kindly provide us with the slides on contributory negligence.
Unfortunately for all of us, the system that I used had been formatted, and I don't have the slides. It's only video. Even when I want to look at anything, I usually have to go to YouTube to look at the video. My system collapsed and I had to format it, and so I don't actually have the one on contribute. I have about 2 or 3, but not contributing negligence, not volunteer, not all these ones we talk about today. I don't actually have them. But if I look at, maybe I'll go and watch the video. If I can see where the information is missing, maybe I can provide. But I may not be able to give you a slides. So if I watch the video, look at some of the missing information and see if I can send them to you. But not in
Okay, ma.
slide form. Okay.
Thank you, ma.
Okay. So in the absence of any other question, before I enter my next class, I think I need to rest. I'll say thank you for coming. I enjoy the rest of the day.
Thank you, ma.
Thank you, ma.
Yeah.